Pulling up to Mickey D's just for drinks? Oh yeah, that's me. Nothing extra, just perfection and a straw. Coming in hot for the coldest cups on the block. Because there are drinks. Then there are drinks from McDonald's.
Mix things up with any size lemonade or sweet tea for $1.49. Perfect with our classic fries. Price and participation may vary. Cannot be combined with any other offer.
Ba-da-ba-ba-ba.
There seems to be a preternatural unwillingness to look at what other countries are doing in the United States because this is the way we do it and we don't have anything to learn from anyone else, which is an odd way of thinking about judging because, I mean, is there really nothing you can learn, including what you don't want to impose in your own court?
Hi, and welcome back to Amicus. This is Slate's podcast about the courts, the law, the Supreme Court, and sometimes justice. I'm Dahlia Lithwick. I cover those things for Slate. Since last we spoke, former President Donald Trump survived an assassination attempt in Pennsylvania before heading to the Republican National Convention in Milwaukee and announcing J.D. Vance as his running mate. Meanwhile, current President Joe Biden said he was absolutely staying in the race, while more and more whispers from more and more senior Democrats suggesting he really should not stay in the race made their way into the ears of national political reporters. Biden said he would not step down unless God himself told him to, or perhaps doctors told him he has a medical condition. Biden tested positive for COVID on Wednesday. As we noted earlier in the week, Judge Aileen Cannon in Florida tossed the entire criminal case, charging Donald Trump with stealing classified documents. Her theory rested on doctrinal vapors. This may be the most important blow to the rule of law in America in recent history, but also J.D. Vance has a beard. Almost lost in this cacophony of headlines and their companion conspiracy theories came a report on Tuesday evening that at last, maybe, perhaps, the Biden administration was considering supporting proposals for major structural Supreme Court reforms, including possibly, maybe, legislation to create enforceable ethics rules and term limits for the 9 sitting justices. And while the fact that the administration is at long last signaling that it's thinking about closing the stable door, oh, lo, these many years after the horse has bolted and trampled the entire pasture, this may have some air of futility to it. It is actually an important step in the direction of shaking off the kind of learned helplessness syndrome about the Supreme Court that we have talked about so many times on this podcast. As we try to gather ourselves up after a truly horrendous term, with a docket so overstuffed it sent decisions careening into July, a term that trashed precedent and any notion that rolling out the immunity red carpet for the coup-prone former president might be bad, I needed to come up for air and to be reminded that it just doesn't have to be this way. And so to do so, I actually went to the home of Justice Rosalie Silberman Abella in Toronto, Canada. Justice Abella is one of the most respected jurists in the world, and she's also a friend. Justice Abella was appointed to the Supreme Court of Canada in 2004. Because Canada has a mandatory retirement age, she stepped down on July 1st, 2021. Born in a displaced persons camp in Stuttgart, Germany on July 1st, 1946, her family moved to Canada as refugees in 1950. Justice Abella is best known for her advocacy for employment equity, for determining the legal context that bars employment discrimination, and for extending survivor benefits to same-sex couples. She is currently the Samuel and Judith Pisar Visiting Professor of Law at Harvard, where she leads a seminar on the judicial role in democracy, in which I got to participate one class this spring. Listener, you may not yet have heard of Justice Abella, but you're going to want to listen to her. I think by way of introduction, I'm simply going to say that in the days after the immunity decision came down, every single show I was on, every single MSNBC show, every podcast begins and ends with, but what can you do? We are the greatest, finest, most perfected democracy in the world. Nowhere else does rule of law exist. The United States court system is the envy of all the world. And so we must live like this forever, even as the Supreme Court rewrites constitutional law to change separation of powers. And so I want to do a show about all the ways that it does not need to be like this, America. And the person I want to talk to is Rosie Abella. And I'm going to call her Rosie because everyone, including my children, call her Rosie. But I should be in your ears hear Justice Abella because that would be respectful. Rosie, welcome.
Justice Rosie. How about that?
Justice Rosie seems like a way to split the difference. But welcome to the podcast.
Oh, it's an honor to be here. It's wonderful. I have been a fan of yours for years as well, and it's so much fun to finally get to talk to you about grown-up things.
Before we start, before we dig into grown-up things, one of the singular things about you is your story, where your parents came from, where you were born, the list of firsts that follow in your slipstream. You were the first of a lot of things in Canada. So can you talk for a minute about, I think particularly in this moment when everybody's looking around saying, that couldn't happen here, you came from a place where it did happen there.
And a place I think that more than anything else probably defined my outlook without even being aware that that's what was happening. I was born on July the 1st, 1946, which is Canada's birthday, but I was born in Germany, so it was no big deal in Germany. I used to think that my parents came to Canada because July the 1st was my birthday, and that was Canada's birthday. But born in a DP camp, my parents and my grandmother, they were the three adults who survived the war, survived several years in a series of concentration camps in Europe. They got married on September the 3rd, 1939, and had a child who was 2.5 when he was murdered at Treblinka with my father's whole family. My father was a lawyer. He had a master's degree from Jagiellonian Law School in Poland, graduated in 1938. It's an 8-year education. And when the war broke out, he never got to practice. So somehow they survived. They told me all of their stories. It was a Holocaust survivors' home, which I learned later was unusual. You don't know how other people grow up until you are older and they start to talk about what that experience was like for them. So I only knew what my home was like. I knew it was a Holocaust survivors' home that was a very happy one, optimistic, and very open. They never shunned those conversations. They talked very openly about what it had been like on a day-to-day basis, what it felt like when they separated my mother and grandmother from my father and sent them to separate camps. My mother's family owned a factory that manufactured roofing materials in a larger city in Poland. They left the baby, the 2-year-old, with a woman who'd worked in the factory for 40 years with some money, because they were being rounded up. They were told by the German Treuhandler, the foreman who had come to the factory, that there was to be a roundup. And they left the baby with this woman and said they'd come back when they knew where they were going and what it was like. And they did. My mother did manage to bribe a guard in this work camp to come out because they thought it would be safe. They came back to the city, Ostrovets, went to the woman's house. She had panicked and gave the baby to my father's family in the nearby town when she saw the Nazis come into Ostrovets. And so my mother went to the town that the baby was supposed to be in, found my father's father sweeping the streets. They had rounded up the town that morning and sent them off to what turned out to be Treblinka. She came back to the camp, told my father that the baby was gone, that everybody was gone except his father, but she didn't know where. And my father stopped eating and ended up in the infirmary where there was a very nice doctor who liked him, I think, because he was educated, maybe, I don't. My father never said, but he said he really took care of him and got him an office job for a while because he was not a strong man physically. My mother was. And then they got separated. These stories about what work they had to do, and my mother helping my grandmother do some of her work, and then going back to Poland when the war ended and avoiding the Russians. My mother said they were very worried because the stories about women being raped by the Russians were rampant. Got back to their city in Poland, found out that my father was in Theresienstadt, rode the rails to Prague and then Theresienstadt, but they weren't letting anybody in because there was a typhoid epidemic. So she snuck in with the garbage detail. Listening to the radio because the Red Cross was reporting survivors to see who had survived. Found him and snuck him out of the camp. And they went to Prague for 3 days, and then they went back to Poland. By then, the Poles were killing Jews, and they had this factory, and now the Poles had nationalized the factory. So UNRWA got them out of Poland into Berlin, and from Berlin, they went to Stuttgart. In Stuttgart, my father taught himself English and went to the Americans and said, I'm a lawyer and I can speak English. What tests can I write to work for you? And they gave him some tests. He ended up being in charge of the lawyers for the displaced persons. And I saw the letters that they wrote when they were applying to come to Canada. He got reference letters from them because he wanted to practice law in Canada. And the letters were so warm and generous and caring and respectful of what he had been through and what kind of a lawyer he was. They were not allowing in Jewish refugees from 33 to 48 until Israel was created, and they no longer worried that there would be an influx of Jewish refugees into Canada and started letting us in. So we arrived in 1950, and he went to the Law Society, as he had to the Americans in Stuttgart, and said, here are my reference letters, here are my credentials, here's my diploma. What tests can I write to be a lawyer? And they said, you can't write any test because you have to be a citizen to be a lawyer. So that would have taken 5 years. He had my mother, my grandmother, by this time a younger sister, and I, and so he became an insurance agent and did fine. Never complained, had a good middle-class life. I never thought about money. It was enough to live a good life. And then it was all about paying Canada back for letting us in. All about making sure we were really good students, 2 hours a day of piano. My mother sent me to the library. There's a library 10 minutes away every Friday. You're going to go take out as many books as they'll let you take out, bring them back, and then next week. And it became a compulsion. And the other compulsion was remembering that my father couldn't be a lawyer and making up my mind in that moment then that I would be. If he couldn't, I was going to do it without having the slightest understanding of what being a lawyer was. So that's the origin story. It is nothing that I really thought about in any conscious way until I had the chance to write a Royal Commission on Equality in Employment. The mandate was, should Canada have affirmative action? It was 1983. And the government was not keen on having affirmative action because the business groups were not keen on having affirmative action. And Royal Commissions were a very useful way of setting out someone or a group of people to travel across the country to determine policy agendas, also to delay
I was going to say, you
policy.
look like you're doing something. Yeah. But you were the one woman.
I was a one-woman Royal Commissioner of a federal Royal Commission, and I was a provincial court judge at the time. And as I was traveling across the country with a mandate to look at what the barriers to employment were for women, Indigenous peoples, persons with disabilities, and what they called visible minorities, non-whites, I started to connect with my own story. Instead of public hearings, I just had candid meetings with each of the four groups, plus business and labor in separate meetings in 16 cities, 2-hour meetings, because I didn't want anything where they were pitching to the press. I wanted candid reactions. And as I heard the stories of trying to get in and what it was like to feel like an outsider and wondering why stereotypes were keeping them out and they weren't being recognized for who they were, the whole theory of what equality means came to me as you can't have equality unless you recognize how different people are. Not the American model of, treating likes alike, the Aristotelian, similarly situated test. If you don't acknowledge people's differences, they can't be treated as equals. So you have to accommodate their differences with the understanding that there's a core, a national moral core of values that everybody has to abide by. So to the extent that your differences collide with those core values, you don't get to exercise them. But otherwise, you come into the mainstream based on your differences. And that's the difference between, I came to understand, the United States and Canada. Because the United States has this abstract theory called the melting pot from Israel Zangvill's play in 1909. This all races are fused into one America, great idealistic sounding theory that makes no sense because it's not true. If you're not white, you're treated differently. You can't assimilate. If you get pregnant, you need to have that accommodated because otherwise you can't be treated as an equal. So Canada integrates. You come into the mainstream based on your differences. You don't have to be the same as everybody else, but your Canadian values are the same as everybody else. So as I listened to these people in 1983 and 1984, I came to a much clearer understanding of what my parents had done by not feeling like victims, not telling me they were victims, not making me feel victims, making me feel that we belonged in Canada, but that we were lucky to be in Canada and that we had to contribute and that we had to make every effort to help Canada be the best that it could be, and that was our contribution to the country. And every single group I spoke to felt the same way. We want to be able to contribute to Canada, and if you hold us back for arbitrary reasons, we're not going to be able to. All of that, as I thought about it, was because of what I had come from and who I was, which I never thought about because they never dwelled on it in my house. It was always, this is who you are. Don't feel sorry for yourself. Don't feel sorry for us. We feel really lucky that we're here. But you are different. You are Jewish. You are female. Be very proud of who you are and then make the best of it. Give back. That is how I came to understand who I was and who this country, what this country is.
We're pausing to hear from some of our sponsors. This episode is brought to you by ZBiotics. There's now a game-changing product to use before a night out with drinks. It's called ZBiotics. Let's face it, after a night with drinks, it's tough to bounce back the next day. You have to make a choice. You can either have a great night or a great next day. ZBiotics is a surefire way to wake up feeling fresh after a night of drinking. ZBiotics pre-alcohol probiotic drink is the world's first genetically engineered probiotic. It was invented by PhD scientists to tackle rough mornings after drinking. Here's how it works. When you drink, alcohol gets converted into a toxic byproduct in the gut. It's this byproduct, not dehydration, that's to blame for your rough next day. ZBiotics produces an enzyme to break this byproduct down. Just remember to make ZBiotics your first drink of the night. Drink responsibly, and you'll feel your best tomorrow. Go to zbiotics.com/amicus to get 15% off your first order when you use Amicus at checkout. ZBiotics is backed with 100% money-back guarantee, so if you are unsatisfied for any reason, they'll refund your money, no questions asked. Remember to head to zbiotics.com/amicus and use the code amicus at checkout for 15% off.
This podcast is brought to you by Slate Studios and SAP. AI is moving so fast. If you don't get reliable and relevant advice, your business might miss out. Welcome to Dear Artie, an advice column from SAP, where we tackle the tricky questions at the intersection of AI and business. Here's our expert, the technology futurist, Ian Kahn.
Hi, I'm excited to dive into today's question.
Dear Artie, the supply chain has been a friend and foe to my company. Can AI make us more resilient? Signed, Supply Chained to Uncertainty.
Hey Supply, here's how AI in the supply chain can help. AI can massively automate data analytics and understand the movement of your goods. AI can point out weak links, market demand trends, optimal logistics, and other important aspects that impact the top and bottom lines for the business. Take the example of a large grocery chain that has hundreds of vendors spread through the country. In some cases, you may need to reroute shipments to other stores, such as in the case of fresh produce, a good that can go bad very fast. Managing such a supply chain is heavily dependent on the data provided, and AI can help optimize this information so that your supply chain works at its optimal levels.
Embrace AI with confidence. Head to sap.com/AI to learn more.
Let's return now to my conversation with Justice Rosalie Abella. I'm just going to read this because you're not going to. Rosie Abella was the youngest judge appointed in Canadian history at the time, with the first Jewish woman appointed to Canada's Supreme Court, the first pregnant woman appointed to the bench in Canada, the first refugee appointed to the bench in Canada. There's so much more. Practiced civil and criminal litigation until 1976, when she was appointed to the Ontario Family Court at the age of 29. Oh my God, barely ambulatory. She was appointed to the Ontario Court of Appeal in 1992, appointed to the Supreme Court of Canada 2004. And then, as you said, had this kind of singular experience doing the commission, the Royal Commission on Equality and Employment. But throughout this, I want to pick up on something you said. Your dad was a lawyer. He recreated himself as a lawyer after the war, and then was not allowed to reconstruct himself as a lawyer because this country would not let him practice law, and you became a lawyer. And I'm looking for a through line. You've now talked about a sort of through line in terms of how you think about democracy and how you think about contributing to Canada, but I'm looking for a rule of law through line.
There is one that was entirely unexpected. Unexpected, unanticipated, but that's a very good observation on your part. So where does this take us in the legal system, and what does it take us to thinking about when we think about the role of courts and how serendipitous everything in life is? The Royal Commission report came out in November of 1984. In 1982, Canada, through the tenacious commitment of Pierre Elliott Trudeau, the Prime Minister, got a Charter of Rights and Freedoms, which constitutionally protected human rights. Civil rights, which are the only rights America really protects or understands, if I may say respectfully, and group rights, which Canada is completely comfortable with, partly because the people sitting around the constitutional table, which is not to say that there weren't more, the Indigenous community was here before anybody else was here, but around the constitutional table, when Canada was formed, were two groups, the French and the English, each asserting the right to retain their own differences, but be equal. And so we have an understanding of the right to be a member of a group and to be equal, and to understand that it's not just your right as an individual, it's your right as an individual as a member of a group as well. The definition of equality, of treating people in a way that respects their differences rather than sameness, treating everyone the same, was on hold when we got the constitutionally protected rights in 1982, because the government decided that it would take 3 years for the governments across the country to re-examine their legislation to see what needed to be adjusted statutorily, policy context. And so 1985 is the beginning of equality for the legal community. It is now a live right. As a result of a new equality provision, which said everyone is entitled to freedom from discrimination based on race, religion, color, etc. That was how it was described, with a second provision that said attempts to ameliorate conditions for these groups are not considered a violation of equality. So that was the recommendation in 1984. It was one person's view. It was me only. I had no committee. And it went to the government, and it was out there for public consumption. What do we do with this new proposed definition of equality? Well, nothing. The government wasn't under any obligation to do anything about it. The first case that reached the Supreme Court of Canada 3 years later was a case called Andrews, in which the court, for the first time, decided what the definition of equality was. And the court said the definition of equality, quoting the Royal Commission report, is that equality is freedom from discrimination and treating people as equals despite their differences, and therefore it is not the American sameness model. And the case involved a provision in the British Columbia Law Society Act which deprived lawyers of membership in the Law Society unless they were citizens.
Like your dad.
Like my father. My father died a month before I finished law school. So he never lived to see anything. But when that decision came out, the provision that had kept him from being a lawyer, being struck down by my words, all those years later, 38 years later, I was a gift to him. And I couldn't believe the arc that started with his not being able to practice law in 1950 when we came to Canada, and the Supreme Court of Canada using my report to create an equality right in Canada that was based on my definition and using it to strike down this provision that I had lived with all those years. So it won't surprise you to learn that I am a great fan of the Supreme Court of Canada. I admired it because in 1982, when we got the constitutionally protected Bill of Rights, we had extraordinary judges on the Supreme Court. And I don't have to tell you that courts, anything, is as good as the people on it, and is a reflection of the people on it. And the 9 people on the Supreme Court of Canada in 1982 just went marching into the field of constitutionally protected rights in full throttle. There was no, let's take baby steps, this is brand new, maybe we should just be a little bit careful, we don't want to make waves. They just went at it. And they protected affirmative action, and they created equality rights, and they struck down the criminal code provision preventing abortion. And I thought, good for them. They're not shy about being bold. They know that their role is, as the Chief Justice at the time said, Brian Dixon, judges are the guardians of the Constitution. And I watched them take the parameters of the Constitution and use it not as something that is a solid block that you have to live within, but take it as the place where Canada's values grew, were explained, were meant to be promoted for the public and for the public interest. And the irony is, that was all based on a 1929 decision of the Privy Council of England, where our appeals used to go in Canada until 1949. You could go from the Supreme Court of Canada all the way to England. Well, in 1929, England, the Privy Council, was dealing with a decision of the Canadian Supreme Court, which said that the word persons in the British North America Act did not include women. And the question before the Canadian Supreme Court was, does the word persons in the British North America Act, when it says the government can appoint persons to the Senate, does that include women? And the court said no, because at the time it didn't include women when we got the Constitution. It went to Lord Sankey, the new Chief Justice in England at the Privy Council, and he said, don't be ridiculous. Constitutions are like living trees. They're supposed to grow with the times. They're supposed to kind of capture the realities that flow. You can't have them as he didn't use the phrase, but they're not frozen in aspic. Is that a mixed metaphor?
Frozen
I can't
in
cook,
aspic?
so
I think we're using amber.
okay, frozen in amber. Frozen in amber.
I think now we use amber.
And it's got to be sensitive to the changing social realities. That became the philosophy that the Supreme Court of Canada judges used. You're not stuck with the words. You're not stuck with the original intent or meaning or whatever the phrase is in the United States these days about originalism. I've yet to figure out what that means.
It changes every 10 minutes.
It does. Well, that is the idea, because we have other things to do, right?
I don't know.
And textualism, of course, the words matter, but they are, again, it's not amber. They are tools to help you decide what rights are for and how to protect the public, and to act as guardrails against the state so that if it goes beyond what the Constitution demands, you have the courts there to rein them in if they go too far in restricting rights. The courts are there to rein them in. There is a huge difference between courts that restrict rights and courts that expand them. I have never seen the role of a Supreme Court to take rights away. And this goes back to, what does democracy mean? There are things that governments cannot do without risking their own jobs. Democracy is a multifaceted component. It is not just about majorities, which I think when you see the wave of populism, you see people clinging to the majority wants. Well, that is a very important part of what democracy means. And there is an institution where those majority views are reflected. You vote for people based on what you want them to say and do, and they are in elected positions so long as you decide, as a member of the public, you want them there. You vote them in, you vote them out. Their job primarily is to reflect majority views. The job of a court, on the other hand, the reason we have independence, by that I mean you're there until you're 75 in Canada, and almost every Western country, I would say every Western democracy, has either a term limit or an age limit on your tenure as a judge. The idea that there is one body that is not responsive to the public, not required to be popular, not required to be liked, not required to be agreed with, in the protection of rights, because there is nothing more contentious or controversial than the question of rights. People feel entitled to their rights. And so you need a body that isn't going to worry about whether they're going to lose their seats after 4 years if they don't do what the public wants. So abortion wasn't dealt with in Canada by the governments. Gay rights wasn't dealt with in Canada by the governments. A lot of very contentious areas weren't dealt with by governments, and that's fine. I don't have any difficulty understanding that. There are people who say, well, it's not fair, it's really...
Judicial activism,
yeah,
right?
And you don't want judges
Right.
doing that, really. Well, but that's the way it works.
Right.
You've got to understand. Plus, the role of the media. That's the other... it's a three-legged stool, as far as I'm concerned. And the other leg is an independent media that is the mirror. And if you're lucky, as we are in this country, of having good national newspaper that can set the moral framework and try to be neutral and just bring together in a filtered way what the truth is. Truth is missing in action these days everywhere. That also keeps democracy going, because it tells us fish don't know that water's wet. It tells us what we look like. So the legislature's responsive to majorities, courts responsive to the public interest, but not to public opinion, because what does that mean anyway? I mean, I hear that phrase all the time. What about public opinion? Well, you've got to tell me who the public is, And do you want judges taking polls to find out what to do? Put their finger in their air and see which way is the wind blowing? Really? Or do you want them to make the best assessment based on the law, precedent, the arguments in front of you, and of course your sense of what you think is best for the country, genuinely best for the country, in an altruistic way? And here I come to the most important feature of a judge, I think. 2, humility and compassion. You have to know this is not about you. This is about what you will look like in 10, 15, or 20 years. And compassion because you have to see what the world looks like to the people in front of you, not top down. You have to understand what it is you're hearing. And that I learned from my clients and from books. I learned empathy from reading those books that my mother made me get from the library every week about what life was really like for people who weren't me. And if you don't understand what life is like for people who aren't you, you can't be a good judge.
I just want to note that the thing that makes me craziest, having been your super fan for many decades, is when Americans call you the RBG of Canada, because I sort of feel like RBG is the Rosie Abella of the United States, and I've, felt that way for a long time. But I do think that there are some threads that are really interesting. And I know you were dear friends, and I know you think about her path and your path because you were both trailblazers at a time when there weren't a lot of women doing it. But one of the things that I find so interesting is that both of you, I think, were such outsiders. The first woman this, the first woman that, constantly toggling back and forth between your lived experience and this world you were supposed to be in that was manufactured entirely by white males, largely to reinforce the power of white males. And I think that double life that you're describing, where you're both you with your experience, your dad's experience, your family's experience, but also now working within the confines of the law, gives you this ability to say, it's not like this for everyone. And so you get that from books, and you get that from your listening tour where you went around the country and talked to hundreds of people. I think that it's kind of the cornerstone of what you're describing as empathy and humility, is understanding that you have to listen to other people.
Well,
and when I think
point.
about what's missing at the current U.S. Supreme Court discourse, there's such a myopic sense of at least some of the kind of current majority. My suffering is the suffering of the world. The suffering of white men is the suffering of the world. The suffering of those of us who are Christian and want. It's such a sort of insular way of looking at judging. And it seems to me like, if I think of the Piaget, developmental stages, it's very young. It's very young to say, I bring to my job the totality of my experience and I'm blinkered to everyone else's.
All of that is true. And the worst part of what you're describing is an unwillingness to listen, but with an open mind, not just listen. I remember reading Walter Lippmann's book, Public Opinion, many, many years ago, and being struck first by the fact that he was 20 when he wrote it, which was amazing. But he said, you have to learn to see first and then define, rather than the other way around. And that's true, because if you, as a judge, make up your mind first about what the issue is and what the answer is, then you are not open. You're not open, which is different from an empty mind, right? You're not open to the arguments that you're going to hear. And that means you're going to impose your views on those arguments, and those arguments are going to take the shape of your views. And that is a breach of the judicial function, in my view. You will sometimes agree. Many of us have had our minds changed by oral argument. Many of us have not. And it depends. But unless you walk into a courtroom understanding that you really have to hear what both sides or all sides are saying, you're not doing your job. And why that matters in the democratic framework that you're really putting this as the context in. That was too many prepositions, but anyway, is that it breaks the checks and balances function, where you've got, as I said, the legislature's responsive to majorities, the courts independent doing what does the Constitution mean in this particular case, and an independent court assessing that. If the court is bringing its own version of what the truth is and not listening, then it's not doing its job of actually checking what the legislative role is. It's just bringing another legislative function in that it wants to impose without having to go back to the electorate for approval. It's a fake legislature.
Right.
When it's not listening, right? Your job is to rise above what your own opinions are, because it is a myth to suggest judges don't have them. Of course we have them. But you have to walk into a courtroom knowing what your views are, understanding what your predilection is, and then actually listening to what they're telling you and being open to having your mind changed. And that is key. That's the humility.
So I'm laughing only because you've just absolutely nailed at the end of a term in which we have Supreme Court justices opining on how to do air pollution better, opining on ozone pollutants, opining on how to regulate guns, how to regulate abortion drugs. It's not just that it's not doing a checking function. As you're saying, it's substituting itself as, we'll just be a better Congress. We'll write some better laws. And it's the antithesis of checking and balancing. It's just arrogating.
I mean, there is a lawmaking function. I mean, the idea that, I remember in the 90s, oh my God, that we weren't impervious to the stuff that was coming from the United States into Canada. Judicial activism, politicians in robes, judges shouldn't make law, they should only interpret it. Really? I mean, this case I told you about, the Persons case, where Lord Sankey said persons includes women, and of course it includes women. That was making law. When you interpret, you make law. But the whole history of common law is judges making law. Mm-hmm. So it was the beginning for me of watching the creation of rhetorical devices to presumptively dismiss progressive decisions of the court. They never used those phrases when the court was behaving in a conservative way, small c conservative way. Mm-hmm. So once I understood what was happening, I came to see how clever it was, but also how irrelevant those labels were. Because what's the opposite of judicial activism? Judicial inactivism? Really? So what you've pointed out, I remember in Justice Kagan's dissent, when they struck down Chevron, because I just didn't like the idea of regulatory, essentially what it came down to, they didn't like regulatory bodies regulating, because they took a view, I didn't say it, but this is what Dicey said at the beginning of the 1900s. Judges are the people who should be making law. We can't have administrative bodies making law. This is the purview of the courts, who are so reflective of the public, not. And so in Canada and the United States and everywhere around the world, we developed these agencies and regulatory bodies who were steeped in expertise about their areas. I chaired the Ontario Labour Relations Board. These people did nothing but labor law. To their horror, they got a family court judge as their chair, because I was the beneficiary of affirmative action. Every time somebody said, we've never had a woman doing something in Ontario, they said, what about Rosie? And I always said, yes, sure. So I learned what a regulatory specialized body was at the Labor Board. These are experts. And when we would go on judicial review to the courts, they were generalists. They didn't get it most of the time. I didn't get it. I had to learn. Some of this is counterintuitive. The FCC, the environment, all of these are highly specialized areas, and you don't have to be a judge to understand what your mandate is. So the lack of humility in saying judges are the only people who can decide law wiped away a whole legal system that was meant to benefit the public. which is not to say you're not going to disagree with the decision. There are court cases where you disagree as well. Took away from the public the benefit of experts who could look at each of these areas and decide based on their understanding of the statute. The idea that statutes, when they are not clear, can only be interpreted by judges is kind of ironic, because the whole theory of textualism is the words mean what they say, and yet when it comes to getting rid of Chevron, they say if any ambiguities have to be decided by courts, which is an acknowledgement that there is often ambiguity in language. So anyway, I was dumbfounded, but not surprised when they got rid of Chevron, because it's a very sophisticated understanding of what the modern state is. Yeah. When Roosevelt introduced all of these regulatory agencies, and we all have them, and we cannot function without them. I mean, look at the courts now. It takes 20 years for a court case, maybe 10. And you're going to add to the burden of these judges now to take on responsibility for all of these expert bodies as well. I mean, nobody's thinking about the public in these kinds of decisions. We need better access, not more obstacles to access. And can we talk about that for a second?
Yes.
I am stunned by the fact that our profession, yours and mine, is the only one that hasn't made substantial reforms in the way it functions in over 100 years. Speaking of 100 years. So doctors have completely decided not to use leeches anymore.
Yes.
Engineers build bridges differently. Accountants do business differently. Everybody does everything differently. But if you took a lawyer from 100 years ago and gave him a couple of hours instructions on what happens in a courtroom, he'd feel totally at home.
Yeah, the pen would be the most confusing thing, right? Going from the quill to the ballpoint would be the big. And legal education too, right? I mean, I laugh because we're still stuck in this kind of Langdellian, whatever Socratic thing, and we don't teach law.
Well, we do.
You do,
yeah. We do it better than we in my day. Oh my God, I am saying I'm not that old. I'm saying in my day. You were taught the rules. That was what law was. That's why I don't like the expression rule of law. I don't even know what that means. I think most people wouldn't know what rule of law means. A just rule of law, maybe. But the whole notion of how you get access to a legal remedy has not changed in over 100 years. Mm-hmm. That is unconscionable. And now we're adding on. That's why tribunals were created, as an alternative dispute resolution mechanism that wasn't going to take forever. But of course, what happens is the courts imposed their values on the tribunals, imposed the same procedural requirements, imposed all of the same requirements to make them mini courts, but now they've taken away even that. So it really took my breath away. And the other thing that took my breath away was the disrespect for precedent that I've seen in the last 2 or 3 years, starting with Dobbs. And the same language was used in Chevron, in a way. Not as hyperbolic, but close. This decision, Chevron, was never right.
Yep.
Never right. The decision in Roe was never right. The idea that you can diss precedent because ab initio it was wrong. All those judges years ago who settled expectations on the public and said, this is the way it is going to be, were wrong. Just because we feel they were wrong. It is the most disrespectful way of changing precedent that I have ever seen. And it's not credible or tenable, and it is so disrespectful of the process and of the integrity of the judges who decided it before.
And of modernity and of common law, right?
That's true.
It's all sidelined for sort of, as you say, this kind of faux originalism sealed in amber at the time of the framing, and that law isn't meant to evolve, even though we have all evolved around it. Time now for a short break.
There's a lot going on right now. Mounting economic inequality, threats to democracy, environmental disaster, the sour stench of chaos in the air. I'm Brooke Gladstone, host of WNYC's On the Media. Want to understand the reasons and the meanings of the narratives that led us here, and maybe how to head them off at the pass? That's On the Media's specialty. Take a listen wherever you get your podcasts.
I'm David Remnick, host of the New Yorker Radio Hour. There's nothing like finding a story you can really sink into that lets you tune out the noise and focus on what matters. In print or here on the podcast, the New Yorker brings you thoughtfulness and depth and even humor that you can't find anywhere else. So please join me every week for the New Yorker Radio Hour, wherever you listen to podcasts.
More now with Justice Rosalie Silberman Abella of Canada. I wonder if I can ask you one last question, because I promised that we were going to talk about how it doesn't have to be this way. And I think you've made short work of originalism, and you've made short work of what it means to dismiss precedent. But I'm coming out of a term yet again in which I have to explain to listeners why they can't listen to audio of announcements on announcement day, why we don't even know when opinion days are because the court gives them to us 2 days before, why we are literally counting boxes in the press office to try to figure out if we're getting 3 decisions or 7 decisions. I mean, the notion that a court, as the U.S. Supreme Court does, conduct itself, forgive me, because this is like the salty analogy I keep using, like the girl that pops out of the cake, at the birthday party in the 1950s, where everything has to happen in the last 10 days and all the big decisions have to come out, but we're not telling you when, and you're going to have to just sit there and read all 200 pages before the next one. I mean, it's insane. And I would love for you to just explain to our listeners how other constitutional courts in the Western world handle this with so much less, not just drama, which is an affront to me, but the power for its own sake.
Well, I can tell you how our court does it. I don't want to speak for other courts, but I've always been struck in the legal profession by the idea that the phrase "we've always done it this way" is a valid rebuttal. I mean, that is not an answer. We've always done it this way. And one of the things that I am always struck by in the United States is an almost, not by everyone, but by many, an unwillingness to look around the world and do a comparative analysis of what happens in other places. It's amazing to me how all the other Western Supreme Courts talk to each other, meet with each other, share each other's jurisprudence, cite each other's jurisprudence, because, we're all dealing essentially with universal problems. You don't have to, it's the vines of France. You can't transport it, but you can look to see what other places are doing, and you learn from it. I learned how not to think about equality by reading American. I read every single decision that had ever been written about the 14th Amendment to find myself saying, I don't like this. It was Isaiah Berlin's line, "There's no pearl without some irritation in the oyster." It made me think about what I did like. So you always learn by looking at what other people do. But there seems to be a preternatural unwillingness to look at what other countries are doing in the United States, because this is the way we do it, and we don't have anything to learn from anyone else, which is an odd way of thinking about judging, because, is there really nothing you can learn, including what you don't want to impose in your own court? Anyway.
And no other courts do that. It's very singular.
It's very singular. That's a good one. No other court refuses to look at any other jurisprudence. And the jurisprudence of every single Western democracy is full of references to other, except American.
Right.
We do not cite American constitutional jurisprudence anymore, and haven't, I would say, for the last 20 years, really. I read it just because I'm interested in it, but it's not cited and it's not followed by anyone. Canada's is more than anyone else, and I remember Adam Liptak doing a piece about that in the New York Times, saying Canada's become the go-to court because it, like every other Western democracy, constitutional court, understands the role of a Supreme Court as being to stay in touch with realities, not to have your finger on the pulse all the time, because as I said, public opinion is not the test, but just to know what the realities are and what is happening in the world around you and what other countries are doing. You can learn from each other. So what my court did, our court did, early days, was decide that the hearing should be not only public, on camera.
Yes. Shocking.
And,
Unheard of.
And not only that, we let people know when decisions are coming out.
What?
I know.
This is madness.
Radical. And more than that, if it's a really major decision, we invite the press the day before to get a briefing from the executive legal officer who will explain the background of the case. The next day, they are invited. They don't have to. They are invited to come when the decision is released, 45 minutes before or an hour before the decision is released, where the executive legal officer will walk you through the decision, and then they go public. So they are on notice, briefed, and ready to go with clear understanding.
So I'm not sitting on television flipping through a 300-page opinion, like reading the head notes?
Well, luckily you can read 300 pages in 5 minutes,
4
but
seconds?
you're special. Yeah.
Mm-hmm. No, I am sobbing, gently, quietly sobbing, because it doesn't have to be a surprise.
If you understand the role of a court, we are only there for the public. We're not there for any of us. When we're gone, I mean, the shelf life of a judge, unless you're Robert Jackson or Brennan, or
maybe Rosie.
Well, whatever.
Okay.
It is not very long. You're there to do the job while you're there to do it. And if you think you're going to protect your role by keeping access from the public, rather than making it more possible for the public to be aware of what you do, they won't understand that you're there for them. I mean, I've always wondered about this June flurry, because if I were a journalist, I'd go out of my mind. These are very important decisions. Ours come out when they come out. We don't have this criterion of let's save the best for last. And in fact, neither do the Americans. There were some blockbusters that came out during the year as well. But it's their tradition. And as I say, they're not open to change, and no one can tell them to change except them. But they have to listen. And I guess for them, it works, but they're not there for them.
So I lied when I said that was the last question. This is really the last question. You are now teaching at Harvard. I know this because I came and guest taught your class.
And we're amazing. We were riveted for 2 hours. I don't think anybody stopped you. You were on a roll.
Here, I think it's really important. You mandatory retirement, you could have certainly sailed off in a RV that isn't as nice as Clarence Thomas's and just had a good time. But you've chosen to teach, at U of T, at Harvard, and to lecture and to write and to think. And I know you well enough to know that's because, as you always say, of what your dad gave you, we're doing this for our young people. We're doing this for our children and our grandchildren. And you and I are speaking at a moment when an awful lot of law professors are telling me, I don't even know how to teach law. I don't even know what doctrine is after this term, much less how to imbue in my students, who come full of aspiration and hope for justice, as you call it, not rule of law, for justice. What are you telling your students right now who are feeling, particularly in the U.S., that the Supreme Court is an emperor with no clothes, that doctrine is malleable, that everything is power? What are you telling them about how to claw their way through what feels like a really fraught moment? I'm going to end this question with the word that I started with, which is illiberalism, authoritarianism, a sense of a sort of tyrannical creep. What are you telling law students that their path is through this?
I don't tell them any of that. That's what you've said is not untrue. I don't tell them that because I don't want them not to understand that they have a role to play in what the law should be. So I do it in my first term, which is the judicial role in a democracy, by comparing Canadian and American jurisprudence. So we will go through freedom of expression, freedom of religion, equality in a comparative way, which they get from some of the other professors at the law school, but it's not common. And they see by the comparison between what we do, when I explain what Canada does and they see what the United States does, there will be a discussion about the differences and why I prefer our approach. So I am, to that extent, judgmental. They know how I feel because they read my decisions and my dissents. I'm at a point because, as you say, I'm retired because every country believes in change and turning over, and none of us has the right to feel we're the only indispensable person who could do this job. There's no such thing. I let them figure out after our discussions what they prefer, and some of them come away, all of them come away surprised at what Canada does because they're not aware of it. They like a proportionality, less absolutist approach to rights. And I don't have to tell them how to feel about a decision like Dobbs. These are smart people who have aspirations to do good. That's why most of them still go to law school. And if I come on too hard about how awful everything is, then it's going to turn off their hope meter. And I want them to stay hopeful and to feel that they have a contribution to make. So I'll walk them through what I think the problems are, what I think the benefits are, and leave it to them. I trust them. Law schools are important incubators of not just teaching what the rules are, and those are important, but what the democratic values are behind law. Law is a function of democracy, and laws work best in a democracy if they produce justice for the most people. It's an inclusion approach to rights. And they come away from many of their classes, I think, believing in that and being worried about their court. Many of them, maybe even most of them, not all. I mean, there are many people who still feel that a federalist approach works better from their perspective, which is fine. They're entitled to believe that. But in my class, through a comparative approach, they can see that there's a benefit to a different approach, which is more compassionate, as a rigor. I mean, I think that's really important. You can't just be a swashbuckling jurist saying, gee, I think I'll fix that. And we're not Don Quixotes. You have to stay within the boundaries. And if you are going to change precedent, which we've done, you have to explain why you're changing it. You have to show how the evolution of time and social realities has led to a reality to be considered that was not previously considered. I mean, the whole history of race in the United States is an evolutionary awareness. Not that it was wrong. It was always wrong to treat blacks that way. And the courts came very slowly. This is why the argument that you have to wait till the moment is ripe, what does that mean if you're waiting from Plessy versus Ferguson in 1896, 60 years, not to be segregated? Why is that okay? So the idea that courts should wait until the time is ripe and public opinion is on your side, you create public opinion by doing what is right. Section 15, for instance, said you can't, equality means you can't discriminate on the grounds including. Including was the big word that allowed the court to say that means if there are analogous grounds to the ones listed, you can protect those rights too. So, gay rights were included by the court. Unmarried spouses, citizenship wasn't mentioned, and that was the first case. So if there is a ground that is analogous to those listed, and it is a ground on which people are discriminated, the court said, include them. That's what happened with gay rights in Canada. The courts just said this is included. And at first people said, wait, what about the legislature? And are you the right body to do this? And after 2, 3, 4 years, we went 12 years. 2002, a panel of the Ontario Court of Appeal that I wasn't on said gay rights are included in the equality protections as an analogous ground. 2004, the first decision I sat on at the Supreme Court. 12 years later, gay marriage, 9-0. Society came to have a conversation about gay rights because the court said, this is a right. You can't ignore this. So courts participate in democracy by starting conversations. So if I had to describe the role of a good constitutional Supreme Court, it would be one that understood that we are there to protect rights, expand rights, and bring in as many people into the rights framework as we can.
Justice Rosalie Silberman Abella was appointed to the Supreme Court of Canada in 2004. She stepped down on July 1st, 2021. She is currently the Samuel and Judith Pisar Visiting Professor of Law at Harvard. And I'm thinking as we wind up that about 7 or 8 years ago, I announced I was no longer a Supreme Court correspondent. I wanted to be a justice correspondent. And I only today understood why. Thank you, Rosie.
Wow. Thank you. It's an honor to be part of your podcast.
And that is a wrap for this episode of Amicus. Thank you so much for listening in. Thank you so much for your letters and your questions. You can keep in touch at amicus@slate.com, or you can find us at facebook.com/Amicus Podcast. Sarah Birmingham is Amicus's senior producer. Our producer is Patrick Fort. Alicia Montgomery is vice president of audio at Slate. Susan Matthews is Slate's executive editor, and Ben Richmond is our senior director of operations. We'll be back with another episode of Amicus next week, and until then, hang on in there.